Let us look at the person who is at the helm of all this, the Deputy Inspector General. The Deputy Inspector General, up to date, he has not given us an OB where he recorded his complaint. What they have done, they have gone ahead to manufacture a letter, which they are saying that that Lagat generated his complaint through that letter. If you again you go back to the Criminal Procedure Code, and you go back to the police order, standing orders, which Houston spoke about, it will tell you the manner and the mechanisms and the mode in which a complaint is initiated. You cannot initiate a complaint through the use of a mere letter. That there is no formal complaint that has been recorded by Mr. Lagat in any police station. That is therefore to say that we are not therefore we are not in pursuing Ojwang for a particular offense. Because an offense cannot be generated or cannot be said to exist or cannot be said to be under investigation in the absence of a formal complaint. They were merely going and seeking to go and torture Ojwang and send him to his grave. Allow me to begin by passing my condolences to the family and the entire Kenyan family for this tragic loss. What heartens me most is that this was well executed by individuals who should have been at the forefront of protecting this life, of saving this life, and making sure that Ojwang, bad as he may have been, was subjected to the due process. But unfortunately, we are living in a country where we have now rekindled people's egos beyond the law, beyond the question of accountability, beyond the question of the rule of law. Simply, in my view, Ojwang lost his life because somebody felt his egos had been bruised. And we are in a situation whereby the country has reenacted the sedition laws that used to be in existence during the time of Kenya. That is to say, the Cybercrime Act is now being used by the excessive regime to make sure that they suppress any person who holds a contra view, any person who appears to be a dissident. They have now resulted into using the Cybercrime Act as the law that President Moi was using, the sedition. Those people of my age remember, and even those who are older than us, they remember the question, the place of the Kenya, the days when you could not speak because Metternich would hear. That is where we are today. I have seen deliberate efforts by the state machineries to make sure that they silence people through the use of this act. So the freedom of expression is at great risk and great stakes because the police are being used to operationalize these heinous attempts to erode all the gains that we have achieved over a period of time. It calls upon us to interrogate whether this Cybercrime Act is still good law in light of the situations we find ourselves, that Kenya is a democratic state, that Kenya is a constitutional democracy. In the light of the constitutional democracy principles, can it then be said that an individual can be aggrieved by a mere text, that a mere text or a tweet can result into the pursuit like the one we have experienced? Remember the case of Njeri, and most of the cases that are currently in court, they revolved around the question of the Cybercrime Act. We must also remember that defamation was declared, criminal defamation was declared unconstitutional by the High Court. And now they have resulted into making selective applications of these provisions of this act. That is one thing that we might have to interrogate. Number two, is a place of our judiciary. And I agree with Shamala when she says that we should be able to place where the issues are. The greatest weak link, or the greatest link that has failed us in achieving what we contemplated, what we desired, our wishes and our aspirations in the Constitution is the judiciary, and not the entire hierarchy. The weakest aspect of it lies with the magistrate courts. Remember, most of the crimes are tried, or most of the offenses are tried at the magistrate's level. The magistrate will be the first person who will interact with a torture victim who has been brought to court by the police. I have the experience that many a times an accused person has been brought to court, and you raise the issue that even before you go to the question of plea taking, your client has been tortured, he has been subject to inhuman and degrading treatment, but the court allows it to pass. Our magistrates are not alive to the fact that being the first point of call, they are the ones who are supposed to enforce the provisions of Tortures Act. So what they do, they tell you go back to the police station, the same police, and record a complaint, failing to understand that under the Criminal Procedure Code, a complaint can be recorded by the magistrates as and when he becomes aware of a cognizable offense. So my greatest frustration lies with the manner in which the magistrates are handling some of these cases. They are the ones who are encouraging the police to continue perpetrating and perpetuating these heinous crimes. May I say, the Criminal Procedure Code provides for the procedure upon which an individual must be removed from one jurisdiction to the other. But you'll find a magistrate seated in Kajiado. Miguna is arrested in Nairobi and purported to be presented before a court in Kajiado. And the magistrate seated does not have the capacity or the moral obligation, if he does not have the legal one, to ask, why do you bring Dr. Miguna here when he was arrested at Nairobi and there are courts in Nairobi? So we must be able to have a concerted efforts where we are having these debate, this discussion, and making sure that all the institutions that participate in the penal justice system appreciate their obligation to uphold, respect, and protect the human dignity. We must bring forth and have a debate between all these arms that they must understand their role in protecting and upholding the Constitution. Allow me to move on the ball as I pass over the mic. Let us look at the person who is at the helm of all this, the Deputy Inspector General. The Deputy Inspector General, up to date, he has not given us an OB where he recorded his complaint. What they have done, they have gone ahead to manufacture a letter, which they are saying that that Lagat generated his complaint through that letter. If you go back to the Criminal Procedure Code, and you go back to the police standing orders, which Houston spoke about, it will tell you the manner and the mechanisms and the mode in which a complaint is initiated. You cannot initiate a complaint through the use of a mere letter. It requires of you to walk into a police station and officially make a complaint. So even as we speak, and I challenge whoever bothers to listen to us, that there is no formal complaint that has been recorded by Mr. Lagat in any police station. That is therefore to say that we are not in pursuing Ojwang for a particular offense. Because an offense cannot be generated or cannot be said to exist or cannot be said to be under investigation in the absence of a formal complaint. They were merely going and seeking to go and torture Ojwang and send him to his grave at as early as 32 or 31 years. That therefore tells you we cannot then be saying that we are investigating when Lagat is still holding office. In normal circumstances, Dibal, in administrative law, where one is suspected to have committed an offense, a crime, or even breached the code of conduct, the law requires of you to step aside and pave way for investigations. And the question and the whole reasoning behind it and the rationale is that you cannot be investigated when you're wielding the powers that Lagat is wielding, and you expect your juniors to investigate you. Who will record the statement from Lagat? None of the police officers, and I bet my last dollar, will accept to record a complaint from his boss. And that is why we are saying any minute, any hour, any day, Lagat continues to hold office in the midst of these investigations. All what will arise and come out of that process will be sham and will be intended to immunize him. Permit me to mention that it is said that Lagat is a highly protected individual. If you were to go back to his origin and even get to note his political affiliation, his political affiliation with the current existing system is that he's married to a sister of a member of parliament. And the wife of Lagat serves as a nominated MCA in Eldoret, was in Gishu County. It therefore tells you that we are not just dealing with a case of a normal individual here, or just a person of an average means. We are dealing with a person which the state has decided to protect, which the state feels that they need this person in that particular position, perhaps to operationalize a particular issue in the future. So in my view, Dibal, we must have a concerted efforts where we are putting these laws into perspective. And I agree entirely that we are not short of laws. What we are short of is the ability to implement these laws, the will and the wherewithal to implement these laws. Finally, Dibal,
Right.
we cannot.
Let me butt in.
Dibal,
Yeah, for the sake of time. Yes. Can you hang on?
Permit me to say that we have filed a petition in the High Court because Lagat has refused to step aside, where we are seeking the High Court to compel him, for the sake of this investigation, to pave way for an interfered process of investigation. That matter is coming up in court tomorrow. For directions, we shall be able to inform the nation as to how the matter and the shape that is taking. Thank you, Dibao.